Be ready. Start. It is evident from the decision of this court, as also the decisions of the English and Canadian courts, that it is not proper to award damages against public authorities merely because there has been some inaction in the performance of their statutory duties, or because the action taken by them is ultimately found to be without authority of law. In regard to performance of statutory functions and duties, the courts will not award damages unless there is malice or conscious abuse. The cases where damages have been awarded for direct negligence on the part of the statutory authority, or cases involving doctrine of strict liability, cannot be relied upon in this case to fasten liability against MCD or the licensing authority. The position of DVB is different, as direct negligence on its part was established and it was a proximate cause for the injuries to and death of victims. It can be said that insofar as the licensee and DVB are concerned, there was contributory negligence. The position of licensing authority and MCD is different. They were not the owners of the cinema theatre. The cause of the fire was not attributable to them or anything done by them. Their actions stroke omissions were not the proximate cause for the deaths and injuries. The licensing authority and MCD were merely discharging their statutory functions, that is, granting license in the case of licensing authority and submitting an inspection report or issuing a NOC by the MCD. In such circumstances, merely on the ground that the licensing authority and MCD could have performed their duties better or more efficiently, they cannot be made liable to pay compensation to the victims of the tragedy. There is no close or direct proximity to the acts of the licensing authority and MCD on the one hand, and the fire accident and the death stroke injuries of the victims. But there was close and direct proximity between the acts of the licensee and DVB on the one hand and the fire accident resultant deaths stroke injuries of victims. In view of the well settled principles in regard to public law liability, in regard to discharge of statutory duties by public authorities, which do not involve malafide or abuse, the High Court committed a serious error in making the licensing authority and the MCD liable to pay compensation to the victims jointly and severely with the licensee and DVB. We are of the view that in appropriate cases of serious violation of life and liberty of individuals, award punitive damages, but the same generally requires the malicious intent on the side of the wrongdoer, that is, an intentional doing of some wrongful act. In the facts of the present case, as we have noticed, the surveyor in charge cum deputy director general of shipping has requested the flag state to carry out the investigation into the casualty within 9 days of the information received about the casualty, and we are not in a position to hold that there was any inaction with malicious intent or conscious abuse or intentional doing of some wrongful act or negligence on the part of respondent numbers 1, 2, and stroke or 3, which was the proximate cause of the disappearance or death of the Indian seafarers on board Jupiter 6. All that the aforesaid declaration requires is that all ships on which seafarers are recruited and placed are covered adequately by the P&I insurance. In the present case, Jupiter 6 was a ship bearing the flag of Saint Vincent and the Grenadines and was also covered by insurance, and the insurers have deposited $40,000. It is difficult for us to hold that the aforesaid amount of compensation is not adequate in the absence of sufficient materials produced before us to show the age, income of the seafarers, and all other factors which are relevant for determination of compensation in the case of death of seafarers, officers, and non officers. Regarding the submission of the learned counsel for the petitioners that this court should declare law in exercise of its powers under Article 142 of the Constitution, we do not think that we should venture to do so in this case, considering the numerous factors which are to be taken into consideration in making the law relating to maritime casualty and the compensation payable in case of death of Indian seafarers. We have, however, taken note of the additional affidavit filed on behalf of respondent numbers 1, 2, and 3. Thank you.